it is 1 o'clock. So let's call this meeting of the Ocean County Bylaws and Resolutions Advisory Committee meeting to order. It is the last day of March 31st, and we do have quorum, so we will be able to conduct business. Next thing is that we, every meeting, we need to just consent and vote to record the meeting. So does anyone object to the meeting being recorded?
No.
No. All right. No. Thank you. As always, I'd like to introduce ourselves. My name is Laura Pangratz, and I am the chairperson for this committee. And my fellow committee members are here. Bob
Hilligus.
Pam Ferendi.
Pete Kaiser.
August Flengy.
Perfect. And our board liaison is
Steve Jacobs.
I'm glad you all know your names. This is for those people who watch our riveting videos late at night when they're, can't sleep and just want to know who put the names to the faces, right? So, and then we have a couple of guests here today. Would you like to introduce yourself?
Yeah, I'm Colette Horn. I'm a member of the board and I'm here for a review of resolution MI1.
All right, thank you.
Jim Travel Association member.
Perfect, thank you. Next on the agenda is to approve the agenda, which I'll be honest, it's hard to keep track of what needs to be on the agenda and what doesn't, because it seems to change minute by minute every time. So here's the basics that we will be covering. Is there anything that I have glaringly missed that we need to add?
The only input I would have on it is under new business, we've got MO1, our guidelines is new business. And it seems like that would be old or unfinished business.
Okay.
But it's a small point.
Yeah, I didn't move it, did I? Yeah, okay.
And
All right. Anything else though?
I would make a motion. We also move that to the first item we address. And that we suspend Robert's rules.
Well,
So everyone
I
in
will
this
do
room
I
can
will do that in
participate.
just a moment.
Okay.
Okay, thank you. All right, next then on the agenda is approval of our minutes. So we will, before we suspend the Roberts rules, we will finish doing our business of approving minutes, since we have to vote on that, and then we will do all of that. So let me find. All right, so here should be our minutes.
I think I need to add one person who was in attendance. You sent me a comment and I can add that and send it back around.
Okay, yeah, I'm not the best tech savvy in figuring out how to update, and so I type the thing in, and if you send back the nice clean copy, that would be great.
I will
So,
do that after our meeting.
so is there anything else that we need to
What was the addition?
he was adding the newspaper.
Oh, okay, the comment. Yes.
Yeah.
Okay.
Cindy Hoffman
Yeah.
was in attendance and I didn't have that jotted down, and otherwise I think there were no changes.
Yeah,
Yeah.
that was, I would say approve the agenda with your notes on it and
Okay. Any
Second.
other objections? Okay, all in favor of approving the minutes with the noted comments, please say aye. Aye. Any opposed? Thank you. Okay. Minutes, public comments. Since we do have two guests, is there anything that you would like to note in the public? Why does that look like that?
It started.
Public, it looks like I threw water on there, doesn't it? I
Yeah,
don't know why I
started
did
about
that.
a minute ago.
Because it looks fine on my screen here. Is there anything either of you would like to do during the public comments part? Okay, all right. So then what we'll do is, before we get to my report and the liaison's report, we will go ahead and suspend Robert's Rules of Order so that we can have a free conversation amongst everyone in the room as we proceed. Okay? So if you look, why it did that. It looks funny on there, doesn't it?
Yeah, what's going on?
And it was fine just a minute ago.
Augie, how does it look on your side? Does the document look all messed up?
I can just see you guys. I'm not seeing the document.
Don't see that. All right, you know what? Maybe I'll.
But I'm able to bring it all up on my own screen, so I don't think you need to put it up on this
No,
screen
no
for my
way.
account.
You just cleared your.
Okay, all right, let me. Am I still screen sharing? I must be. There we go.
There we
All
go.
right.
Clear an error.
Okay. Okay, so, chairperson's report, that's me. So I did attend the directors meeting on March 18th. I did speak as an individual, not in representative of this committee, during the public comments about B09 to recommend the video retention policy for committees be a little bit longer than 2 months. Because as we can tell, many of our topics come back around and take a little longer than 2 months to be accomplished. I also emailed to Michelle Ross here the approved minutes of the February 24th meeting that we approved at the March 10th meeting to add to the website, and the agenda for today's meeting to be added to the website, which she did. I did attend the volunteer recognition dinner on the 23rd at the Yacht Club, and I did name and mention each of you and thank you for your commitment to the committee. Bob and his lovely wife were there, sat with my husband and I at our own table, and we had a very nice time.
Nobody wanted to join us.
I know, we had extra seats. So my future tasks obviously are, I list all of the upcoming directors meetings on there. Okay. Excuse me. Next up is Steve. Is there anything you would like to update in your report portion before we tackle some of the bigger topics?
I don't think so. It looks like for the April meeting, I will have a motion for the board to approve B03, which deals with association members' meetings. I'm sorry, that'd be a first reading for B03. We forwarded the charging document. And the other one would be we may have to do video recordings and because that had. The only other thing I would say is some of the matters that came up at the last board meeting were bucked to, I guess, budget and finance, which was the unnumbered financial resolution that we found. And we haven't gotten anything back from them. We did get stuff back from council on B05 and B06, which you have, which I did not see until yesterday. So I apologize for not getting it out to everybody, but it'll be up. Laura and I talked, she's got it up ready to go on the screen. And in my defense, my wife and I attended the volunteer dinner, and my wife wanted to make sure she had an opportunity to speak to Amy Peck's husband, who have been sharing stories about the issues of retiring from the federal government. So we sat at their table. It was not meant to be a slight to Amy. It was the only way I could get her out of the house.
We just had more drinks.
Anyway, so that's that was it's a very nice evening. I think everybody had a good time.
Yes,
But
that's very well done.
I just have one question. So in the notes, so I tried to transcribe the notes onto the tracker, the updates and things. Right. And some of the notes said Discussion was held, let's see an example of one. Discussion was held, scheduled for first reading at the next meeting.
Right.
But if you discussed it, isn't that a first reading?
Well, it went up as we were talking about.
There were a couple of things. It was like B03.
Yeah.
B09.
Uh,
Yeah, 9 is listed
Oh, no,
incorrectly
but
there.
09 went up as a first reading.
That one's first reading and it's up to the board to decide what they
Right.
want to do
So,
for the
The
second
first
reading.
reading was done. I now will prepare a motion for the board to take action one way or the other. And then if the board wants to amend it, they'd be free to do so. They can table it, they can do whatever they want. The B03 we brought up to the board as a charging document.
So in other words, they reviewed the charging document maybe, but not
Well,
the.
hold on, let me make sure
On what?
I think that's correct.
Which one are we talking about?
B03. And the
Okay.
reason why was, if you remember the discussion we had, B03 had come up last summer. It's a little unclear if the board formally tabled the motion or just put it aside or anything else. But anyway, since the election, everything else, it was sort of decided to bring it back to the board as a
Right.
charging document for them to at least begin to think about. And so that we sort of, I guess the easiest way to look at it is we sort of lost a month. But if we were just dealing with what the committee had done, we probably could have brought it up as a first reading, but because of the prior history, we went back and said, this is the charging document.
And then it's a new
Gotcha.
board.
Yeah, so I will bring it back.
Some had not seen it, we
Right.
said we were gonna restart it. And
What
so-
about B02? Same thing. Discussion was held.
That will be discussed in a few minutes.
But also that wasn't considered a first reading. B02.
That's
Not-
not the
not
way
at
I
this
heard
time.
it, but I
Okay.
could have been wrong. Since I was just sitting in the audience part.
So these are your,
Those are my-
okay. I didn't know if Steve had sent you this.
No.
No,
Gotcha.
because when I,
Gotcha. Okay, then
when
we'll
I
just-
sit there, I mark and I listen.
Gotcha. Okay.
That, okay, they
And
did
what-
the first reading, and it was completed, so.
Gotcha. And once the meeting's over, I try to erase my memory banks anyway.
So, all right, so, under the unfinished business, before we, talk about M01, then, are there any other ones on there, Keith, that you had questions about for your tracker?
No, it was just,
Or were
it was just
because I just kind of
clarification on the
read-
ones.
I just kind of relisted that
Yeah.
stuff because they were all on the agenda from that past director's meeting.
Yeah, so the one I emailed a new one out today and I went through your notes and I tried to update this with your notes. So we had a good starting point to go over today.
Okay, all right.
Those were the only questions I had.
And then obviously, at our next meeting, all that stuff I will take off of the unfinished because now we're updated
Yeah.
on it and stuff like that. So, all right, so let me find. I'm gonna jump to M01. So I have the resolution, it's the bigger one. I have so many copies of. I can't keep track of.
Yeah, what was?
You want the
Well,
one with
they
the
It would have
comments
been
then?
helpful.
They should have marked it as draft and put a date on it.
Yeah, that's, I was trying to say, it's a little tough to keep track.
Sorry.
Well, that's for your committee, not for you.
Yeah, we didn't make many changes, or they didn't make many changes.
Okay.
I know
so-
you guys discussed it fully. and,
Yes.
Did it make changes to the red lines you recommended or did it make changes to the original?
They, to the original document, there were a few changes, but not many. What we did the clerical changes, or they did the clerical changes. Let me see, and then it came down to the first notice of violation, step 3. They made change, they took under advisement your recommendations regarding that. and created language that they feel is consistent with what you recommended. And then they fixed the place where it was the notification of the need for a second. This is under step 3, need for a second notice of violation, where they had CPI/ARC. They cleaned up that language. And then I think, let me go down here and see. That was really, oh, and then they did not feel that calling this an appeal hearing was appropriate, because it's not a hearing at which the ARC's decision would be appealed. It's a meeting at which the violation is going to be appealed. It is really a meeting where the homeowner is appealing to the board not to restrict their property rights or their home ownership rights as a result of their continuing violation. So they felt that the violation should be called an appeal violation, or an appeal hearing rather than a violation hearing, because they don't want to send the wrong message. The board would overturn the ARC's or the CPI department's finding of a violation. That's not what those hearings are for. They're to allow the homeowner to ask that the penalty of restriction of property rights not be imposed. So they went back to that, calling it an appeal hearing rather than a violation hearing. And let's see, I think those were the, and then the flow chart that that Keith prepared is beautiful and slick and easy to
Scroll
follow.
down, did you say?
The flow chart,
Okay.
they decided that what they had, even though it looked complicated, was more accurate to what the process is. And they did not expect that process chart would become something that the homeowner would use. It's really something for the staff to use to keep track of their own process. And so they agreed with Pam that these are adults who can read, and that the text in the resolution gives them the information that they need. And if they have any questions, they can certainly reach out to CPI or the ARC to get clarification. So to put all of that into a flow chart, they felt was just really going to be difficult. And so they wanted to keep it as a process chart that would be a kind of parallel the language, but meant to be used by the staff. And
So operational.
yeah,
Therefore, it would be in the resolution.
exactly. Yeah. And so they even, Josh Vickers, the chief inspector, CPI inspector, even tried to make a flow chart out of it himself with some software. And it looked pretty, but it just wasn't going to meet what the ARC felt was their purpose in having that process chart. So,
Because I think maybe there was a disconnect, because their process chart for their own internal use is one thing.
right.
Putting some sort of graphical representation in the resolution for either the board or whoever reads the resolution to try to understand this concept of two paths. I think that's what we discussed.
Right. Yeah. And they didn't feel that they didn't deny that might be desirable. And that, I think, is why Josh Vickers went forward and tried to create something. He wasn't able to create something that accurately captured the flow that might be conveyed in that chart. And so I suggested, instead of holding the resolution up for that flow chart, let's see if you guys are okay with the resolution going forward, that there are no conflicts with the other governing documents and the resolution itself is ready to go to legal to review. And then, I don't know if they're gonna ask Josh to revisit this, or they asked if perhaps you would be willing to work with them on a flow chart. Didn't think it was appropriate for me to commit you.
Thank you.
I've got your flow chart up there, and this is the one.
My question, I took that chart that they gave, their process chart, read the resolution, and I couldn't tie them together. They know what they're doing, so that may make a lot of sense to them.
Yeah,
But what I thought is if they took this simple flow chart and just got the highlighted area, so a homeowner knows exactly what's going to happen if they have a violation. They get a quick overview that they're going to get, and all they would have to do is draw a couple lines where they want to make additions to draw attention to it. But what it's really saying is, if you give me a violation, I got the right to appeal it. If I win the appeal, it's done. If I'm wrong and I have to make the correction, now it goes through the next process, correct? And the process is either I got to fix it, you're going to repair it, or you're going to go to court. But I get to appeal one more time.
well, you don't get to appeal the ruling of a
No,
violation.
but I get to appeal whether or not they're going to take my rights away, correct?
Yeah, that's the only appeal that you
Right.
get.
Right, that's what I meant.
Yeah,
And
and so, and that comes at the point of the second notice of
Right.
violation. Yeah.
And if that is included, then an owner understands, then,
Well, the owner receives a letter that says that.
but if somebody wanted to look at the resolution and they could look at a flow chart that ties to the resolution, it would be helpful. That's
Yep.
all.
And I think that ARC conceded
This is
that.
really the most complicated resolution,
Yeah,
probably of all the resolutions we have. And it's important
right.
because, I
But
walk
bear in
around.
mind, sorry, go ahead.
Go ahead.
Bear in mind that the homeowner gets 2 letters explaining where they are in the process currently for the first notice of violation. And then a second letter that explains the rest of the steps. So I think that is meant to make it clear to the homeowner, first of all, what their violation is, what is expected of them, and then what will happen if they don't correct the violation.
But that's only if somebody has gotten a violation then, that they get such detailed information. You know
Yeah,
what I mean?
yeah,
If we're trying to help educate all of us before we get a violation of the steps, a nice, easy, quick visual might be helpful to be able to understand that, hey, if you're found with a violation, first you get this letter, and then you get the second, you know what I mean? And then tell them all that. This is coming at it from that they've already gotten a violation. And they're now expected to understand the process.
But the thing is, if you looked at it as an executive overview to tie back to the flow chart, that's all it would be. It's an executive overview. It does not get into the level of detail, but it gives you a good overview. It's not operational. It might help a homeowner that clean up his property before he ever gets a violation. I mean, the area I walk through in Ocean Pines every day, there's about 4 or 5 houses there that just look like trash.
Oh.
And I know they're not even on the list because neighbors don't want to report them. I don't care. It's not my problem. For my neighborhood, it would be a little different.
yeah. So I guess what I'm hearing you guys say is that you
Well-
feel that the resolution is incomplete without that flow chart.
That's
Okay.
all my opinion, not the,
So,
I was wondering,
go ahead,
go ahead, Artie.
go
I
ahead.
mean, in my view, I think the language of the resolution is like what you're really going to follow rather than like a picture. But I do like the idea of maybe recommending that after the resolution's adopted, that the general manager like develop a flow chart to make it easier to understand. Is that something that can go along with this, or is it like all or nothing?
Yeah, well, the committee was amenable to that. And that's why I'm here today without a flow chart being asked to be reviewed by you guys, because they felt that let's get this approved and make sure we've got all the process consistent with what the legal review would approve of. And then we can think about a simple flow chart for homeowners. They want to keep their process chart for themselves for operational use. And I think that makes sense.
I think for me, I think we have to separate what we as a committee are charged with versus what we as individual and maybe association members think about it, right?
Right.
So I think as a committee, I mean, correct me if I'm wrong, our charge is,
just to make
is,
sure.
does this conflict with any other standing
Right.
written documents that we're aware of? So if it gets approved as is, it will not be standing in conflict of anything else.
Correct, right.
I think that's our primary tasking.
Right.
And essentially, all the rest of this discussion, while it may be helpful, is just our opinion that maybe it's not the best, or it could be written differently, or are we this flow chart or that flow chart, but it's not really our tasking.
Correct, right.
It's just, I think Keith is correct. Let me just go backtrack a little bit. The reason why M01 has gone through the revision that it has is because the General Assembly changed the homeowner statute, granting the homeowner a right to a hearing, whatever you call the hearing, granting them the right to hearing for violations that have not been appropriately addressed. Maybe is the best way to phrase it. And so I think ARC has completed their work on hearing. It sounds like we've completed our review of ARC's work. And on that basis, I think we're pretty much done. Right. I do think it might be helpful, and I'll leave it up to Colette how she wants to do it, but it might be worthwhile to inform the board when this comes up for debate that both committees, acting actually independently, believe it is worthwhile for a simple chart to be developed so that homeowners can be aware of what they might face if there is a potential violation. In other words, I get what Laura's saying. It's worthwhile to educate everybody. Look, we all know what happens. You buy a property here, you get the bylaws, you get the DRs, you get everything under the sun, and nobody
Put them
reads
in
it.
a,
Nobody
put
reads
them in a
the
drawer.
file.
Right. I mean,
Right.
we all know what happens.
Right.
So whether or not you attach a chart to it,
Right.
or whether or not ARC ultimately decides when they send the first letter, here's a simple chart for you to understand what's going on. That's an operational question. I don't think we should get
I agree.
involved in that, but I do think it might be worthwhile to let the board know that someone, whether it's the committee or the general manager or the two committees acting together, however you want it, or an ad hoc committee, I don't care how you do it, it's worthwhile to look for a simple way to explain this to the homeowner prior to, the
Getting
risk of any
into-
particular
yeah,
problem.
right.
But that is separate and distinct from getting N01 off everybody's desk
Right.
onto the committee, onto the board for consideration, because the clock is ticking on that score.
Yeah.
Right. Can you refresh my memory? Which committee did all of the video tutorial kind of things that we put on the YouTube channel? Like here's welcome to Ocean Pines.
That was communication.
Is that communications?
Yeah.
Might I suggest that once some of this has been all finished and everything, that could be a nice little video tutorial that says, hey,
Good. Yeah.
you're not violating
Yeah.
now,
That
but
probably is better than.
here's
flow
a
chart.
great verbal
Yeah.
quick,
Yeah.
that might be a topic that
Yes.
committee could consider doing a video for, because based on our own conversations and what we're hearing that ARC feels about, we're just concerned with the verbiage here in the paper, but I
Yeah.
do think it would help to educate people. And if that's the point of those kind of videos, that might be a good topic to say,
Yeah.
we want to let you know before you end up getting
Have you looked at those videos?
I did. It's been a couple of
Yeah,
months.
and I
but
looked at it a long time ago. I don't
Yeah.
remember if there's anything at all about this.
I don't think that was one of
I
the
don't
topics.
remember seeing it. I looked at a bunch of
Because
them
I
because they're
pretty
good.
much watched
Yeah.
all of them, but it's been several months and no
Yeah.
new ones have
That's
come
a
out,
great-
so.
That's a great suggestion.
Yeah.
And I think the other thing that ARC was concerned about is that the language of the resolution rules. And if you have a chart that somehow inadvertently can be interpreted in conflict with that language, then we may have a problem.
Right.
But that chart
That's
is part of the resolution, because the language of the resolution is really what rules.
But maybe.
So, but I think your suggestion is a great.
So,
I think the video is the better.
I think it's a great idea.
Yeah.
Yeah, I think it's,
Yeah.
and it's, you know, it's one of the, when it comes to topics about the association, it's probably like top 3, top 5, you know, that people are concerned with. So I think that's a great
And
idea.
it also helps with the transparency part, you know, like if we're being
Yeah.
obvious
Yeah.
about how do you find the violations? How do you know what I mean? Tell everybody what the process is, you know?
So I think for our feedback back to the, because we have a charging document on this, right? So we got to provide feedback to the board.
I believe so, yeah.
So,
Do
you
we
know,
have a chart? No, we
didn't have a charging document?
I thought we just got the
I
resolution.
think I did one. I thought the board sent it to us
Yeah.
and said, could you look at this?
Yeah.
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 So it seems like we'd have a formal response of, as reviewed, no conflict is seen with any other standing resolutions.
Right.
And then we could have an informal response that, you know, I don't know, you know, some of the language is, that it's a complicated resolution. There's a lot going on.
Mhm.
Maybe in the future, there'd be opportunity to simplify it. You know, so I have a formal answer to the charge document. And if we wanted to provide any informal feedback, you know, we could do that, but we would separate them
Right.
on our charging document so that we can answer the mail and get this check box.
I think all you really need to do at this point is vote to adopt
Do you have
what Art
copies?
has brought back. So it's after we gave them our edits, they looked at it a second time, and the committee really just needs to vote on what Art has brought back to us. And then Colette can prepare a document to bring to the board. I don't think it's really.
Well, it really needs to go to legal review next from you.
Is that what you want to do, or do you
That's
want to bring it up?
what I
and let it
understood
get go to-
that you guys had recommended. Yeah, we did.
Okay,
Yeah.
all right.
And so I would like to get it off your agenda and onto general counsel's agenda.
All right. so I
Jim,
think I
do you have
found,
any-
is this the correct?
Jim,
charging?
you live with us.
I think I found the charging document for it.
Yeah, so there was, I was wrong.
That's,
Yeah, because the big thing we wanted to do is make sure it's in compliance with the new law
Right.
and that it doesn't
it
conflict.
was started
with any of
back
our
under
existing
Jim,
documents.
but yeah.
At the risk of being
Go ahead.
A, out of order, B, at variance with the consensus of everybody here, I think I have to make a couple of comments. I want to make sure that the process is in fact correctly identified and understood, because there's an insertion in here that was not in the draft that came before the one we have here, and has not been highlighted. I sent an email around to the members here, and that's in the step 3, paragraph A, I believe it is, where it's inserted. Let me get to it myself.
Want your email, Jim?
So step 3, subparagraph A, the second sentence, which is the last sentence, 2 sentences. Notification, we're talking about the notification for the general manager to go to legal. Notification will be delayed until after the time by which responsible party must request an appeal hearing by board, or if an appeal hearing has been scheduled after the completion of the appeal hearing. That is the correct, in other words, it doesn't go to the general manager for any action until after this appeal hearing. Is that has to be the understanding of that insertion, but is that the understood understanding? And as a side comment, the process chart, whatever you want to call it, that is not being included in here, does not show that either.
So this,
It shows the parallel, you go to the board for sanctions, and then you go to and simultaneously go to the GM for to go to legal. That is not the process of this resolution draft. It goes to the board, and the board must act on sanctions, and then it goes to the general manager for his action to go to legal. I just want to make sure that that is in fact the correct understanding of this
Yes,
draft.
yes, there's an earlier step in which the GM reviews whether his staff can correct the violation. There's some
Oh, yeah, but that,
removal of trash, minor violations.
I understand that.
Yeah.
I understand that.
So there are 2 points at which it goes to the GM. It goes to the GM to say, can we fix this or do we need them to fix it? And if we can't fix it, then it goes to the next step, which includes going to the board for the second notice of violation, and then to legal for action if it is deemed to be a continuing violation.
Okay, well,
Yeah.
then what you're saying there is the process that goes to the GM, and the board's on hold until the GM tells him, I'm not coming to you to make any proposal to take care of it ourselves.
Right. And that's not in there.
Okay, again,
That's what you're saying.
I'm not gonna argue with that. That's wrong word on my part. It's outside the discussion as far as I'm concerned. I'm not putting pro or con on that. It's a question of whether or not it's understood. And we have 2 board members here. They're gonna have to understand it. That's the main reason why I'm asking these questions. But the basic situation is that we are not going to legal till after there is a hearing or a hearing scheduled and nobody shows up.
Give me the citation again where you were in this.
Okay, it's step 3. Yes, I think that's paragraph 6, but step 3.
First notice of violation, 6.3A.
Yeah,
6.3A. And then if you look at A, halfway down, sentence starts with notification will be delayed.
that sentence is an addition to the draft. What to me that does is clarifies. In the last meeting, and I got us off on this. In the last meeting, we were talking about a parallel process.
Right.
It goes up the CPI process steps to the general manager. The general manager starts his process to the attorney simultaneously with the ARC CPI step to the board to start a sanctions. Simultaneous. That's not what this is. What this says. What this says, you can go to the general manager, but he can come to the board and say, "Well, I'll fix this," but it's not going anywhere outside the association until after the board hears
in the hearing.
it. It's not going to go to the attorney.
You mean a requested hearing?
Until after the requested hearing process is completed, either a hearing or they don't show and that process takes place.
Now, the law allows, my understanding of the change in the statute is that the only thing that the homeowner can request consideration for is not having membership rights restricted. It can still go to legal. All of that can happen without a hearing. The law does not speak to, you have to stop that whole process.
Okay, but again, my understanding of what this draft says is that's not what it says. And I don't know where the interpretation of the code provision that you're speaking of. I'm going to respectfully disagree. The code provision, we can get it out here and read it, has throughout it alleged violation, alleged violator. And if you read the wording about the ability to call witnesses, cross-examine witnesses, that's effectively a quasi-legal process. I see no basis in it. If anybody's saying that the code does not permit the alleged violator to come in and say, this ain't no violation. You have no right to try to suspend my rights of any kind. There is no violation here. There's no reason, nothing in the code says that can't be done.
Yeah, and I wonder if maybe there's somewhere in one of our documents, because this came up once before when we talked about this, there's language that essentially says the board can't question ARC's decision. You remember that?
Yeah.
And so what I'm wondering is if ARC is subconsciously applying that to their interpretation of the statute that Jim was just referring to.
It's conscious, not subconscious. They're consciously.
In other words, if our
Okay.
own internal documents say you can't question it, then that must mean what the state means. No?
Yeah, I'm gonna give everybody my opinion on that. I want to kind of get out and keep moving on to a couple of other comments. ARC's unquestioned authority, if you can put it that way, deals with the permits process. It does not, in the governing documents.
Right.
Now, if the board wants to give ARC all the authority to do whatever it wants to do, well, that may come up against some questions of policy.
Okay.
But the ARC governing documents authority of unquestioned authority, or unquestionable, whatever you say, is with regard to permits.
Gotcha. I will just say with regard to this paragraph that Jim pointed out, I've read this now, just sitting here 4 times, and I don't understand it. I don't understand what it
All I
means.
can say is I've given you my understanding.
No, I read it and I looked at their chart and I tried to tie it and I can't get it to come together.
I don't
That was my
understand how
problem.
the
I'm not
notes-
saying we need the chart.
Notification will be delayed. So general manager can't solve the problem. So the general manager goes to the council and says, hey, start your process. Okay, I get that. So I get the first part of it. Notification will be delayed until after the date by which the responsible party must request an appeal hearing by the board of directors.
Right.
Notification of what? That it's been sent to the council?
Notification to the council, I think. My interpretation of this is they don't want to go to court if the board is going to have a hearing still, because who knows what the board will do, is my guess. They don't want to get ahead of the board, maybe, if they're having a hearing on the violation.
So you think that means that the process where the GM goes to the legal counsel, that process, or the GM notifying legal counsel, that's what they're talking about. That will be delayed until after the date by which we're responsible.
Yeah, I don't think it's the first. Maybe the word notification is confusing there because of this whole thing is about the first notice and the second notice, and this looks like it's more nuanced. It's just a notification to council.
I think,
Well, that would make sense if what, now maybe, I don't know if that, is that what you
So
said? Is that what you thought it meant?
Sure.
That the word notification as used in this sentence is referring to the previous sentence process whereby the general manager contacts legal counsel.
That's exactly what I mean.
Okay,
so it should be communication, not notification.
Let-
Because I think what they're saying.
because the word notification is being used throughout this document in a very specific
But
way.
I think what they're saying here is, correct me if I'm wrong, but what I'm hearing is as to the first notification, ARC has taken a step to inform the homeowner, Lotto. And the GM is now telling counsel, legal counsel, open a file. Because this is what's going on. I'm putting this in plain language. So really what we're saying is, as to the first notification, what the GM is telling council is, we've begun the process, open a file. We'll give you more, ultimately, we'll tell you what happens as we go along. But it's a communication, it's not a per se.
It's not a letter of
Notification.
notice, it's a,
And just to go back to Jim's point, the statute itself specifically says procedures required before imposition of fines or infringement of rights. Part 1, the board of directors or other governing body of the homeowners association may not impose a fine, suspend voting, or infringe on any other right of a lot owner or any other occupant for violations of the rules until the procedures in this subsection are followed. So ultimately, what I'm hearing is, as to the, if you get to the second notice to the homeowner requests a hearing. The subject of the hearing is really whether or not there's a violation, because ultimately the board's got to take two steps. One is they got to decide whether or not there was a violation, and if there was, what are they going to do about it? So there's really sort of, now they all do it at the same hearing, but you know, you don't get to. You have to determine if the board agrees that there has been a violation, it hasn't been remedied, then the board has a decision to make as to what to do next. That's the way I'm reading this.
I still have one remaining question, and that is, does the board have the legal authority to override this committee that says it's a violation? Because what Jim is saying is in the declaration of restrictions, it's restricted to permits and permits only.
That's my view of it.
Yeah, I mean, we need to get,
Authority for.
definitely there needs to be a legal opinion on that, because somebody is going to take you to court on that kind of issue.
Well, that again, that should go to legal.
No.
Yeah.
I understand. I'm just saying, before this committee approves something, we need to really understand
I think
whether
I
it's
need
in
to have a
violation or not.
conversation with Jeremy about
But
this.
keep in mind, I'm not, I understand what Jim is saying. I'm not saying he's wrong, but
No.
the ultimate decision, as with everything under the statute, rests with the governing body, the
Right.
board of directors.
Right.
So even if, I mean, there's nothing that says within, I believe, within the statute that says the board of directors is prohibited from delegating certain authority other than permitting
Right.
to appropriate committees. And that's not there. So the board of directors is chartered, if you will, are to cover the whole issue of violations of our DRs and everything else. If that's the case, and that maybe that's something that needs to be adjusted, I don't know. But in all cases, the ultimate decision is, from the statute's point of view, rests with the board of directors.
The ultimate decision as to the violation.
Well, as to the violation, as to any penalty, but also as to the scope of authority that is granted to, in our case, to ARC. Because unless I'm missing something, and I don't, it's been a while since I went through it, the act itself limits the responsibilities of the association only to the governing body. They don't really they don't engage in the question of whether or not there's committees and whether the governing body has delegated authority to the committees and who the committees are, or anything like that. So everything rests with the governing body, so which is the board.
Right.
So in deference to Jim, if the board has limited ARC's authority to only permitting as a general rule, then that needs to be adjusted for some reason. That language probably needs to be adjusted. But you still, what all I'm saying is the board has the authority to do that now if there's a need to do it. That doesn't get back to what's embodied within the statute.
I trying to think how to say something here. My interpretation of the ARC guidelines is that the unreviewable authority, if you will, of the ARC committee, not the guidelines, the declaration of restrictions, the unreviewable authority of the ARC committee deals with permitting of new improvements on the property, on unimproved property, new improvements, existing property, new improvements. If the board wants to, in some manner, some document, resolution, may not be properly the ARC guidelines, but the bylaws, whatever. Delegate to ARC that they are the final decision on whether there's a violation. That's another story. But in my opinion, that does not exist right now. Whether they can or could do that is another question.
But Jim, I think that based upon the statute, that ARC is not vested with the final
Well,
authority.
I agree. I'm not just
So
saying.
ultimately, there may not be, perhaps there's no conflict at all, because the statute sort of resolves that issue. It simply says governing authority, board, ultimately decides whether or not there's a violation. Now, I think that goes back to your question earlier, which is the nature of the hearing where you're allowed to call witnesses. And you're right, it's a quasi judicial hearing based upon that. In fact, it even goes beyond that, because at the end of the act, someplace, if I can find it, the lot owner may be sued for damages caused by the failure or for injunctive relief, or both by the homeowners association or any of the lot owner. Prevailing party in any proceeding in this subsection is entitled to an award for counsel fees as determined by the court. I mean, ultimately, there's another review of what the governing body decides. But based upon that description, I think you're correct. The hearing, and I think it's supposed to be an executive session, as I recall as well. The hearing before the board is I think your description is adequate, quasi judicial hearing. Board has to render a decision and determine whether or not there's any particular penalties. But I don't think there's anything that conflicts with based upon the statute, with that renders what the committee has drafted in M01 from proceeding. Unless I'm missing something.
I don't disagree with that.
Okay.
No.
Well, I think a problem, I'm sorry.
What's in the understanding of the process of that's going to go into place with this resolution is what I'm.
Yeah.
interested.
Well, yeah, and I think this thing that you guys grappled with last month, upon the recommendation of ARC, CPI will forward the case to the GM for consideration. When I look at the authority for this, you are correct, Jim, that the authority of the ARC is permit. It has nothing to do with violations. And I think if they take themselves out of the CPI is allowed to consult with them and allowed to consult with anybody else that they feel they need to consult with, but they have no role in this violation process. And I think if that language, any language referencing ARC being involved in this should be removed from this.
I agree with you. I struggled with that last time we talked about that.
Yeah.
I kept thinking, why is ARC a part
Yeah.
of this?
Yeah.
This should be between CPI and the GM.
Well, and actually I went back the next meeting. I said this, I couldn't answer this question for the bylaws committee, whether you guys are doing motions or how is this going from Josh reporting back that a violation still exists to it then being forwarded for the next step in the process. And they were fuzzy on it. And I said, well, are you doing motions or is this assent? So in that meeting, they did motions, but I don't think they really have a role.
So what?
Now that, I mean, you guys raised good points
So what
here.
are we saying? As to the first, besides the second violation, as to the first violation, CPI notifies where was it?
CPI sends a notice.
So we'll notify board of directors to send a second note, but if we're still in the first violation.
Step 3, under step 3,
Right.
CPI will send the first notice of violation as defined above
Right,
to the responsible party.
right,
CPI did it.
right.
But I think that I'd have to look, but I think it's on the signature of the chair of the ARC. And the chair of the ARC should have no role in that.
I agree.
So when I go back to
And then
the
it goes on to
authority,
say CPI can send board of directors, notify board of directors about a second notice.
Right, that's on step 3, that first paragraph.
Yeah.
so and here under responsibilities, the board is responsible to the membership for the overall compliance program. The GM is designated as the individual under whose authority the compliance program is to be administered. The GM may delegate any or all of this, which he or she has done, or they have done, to the CPI department. And how, I'm new to ARC, being their liaison just a few months. I don't know how ARC got in the middle of it. If it is this new inspector, chief inspector, who's not been on the job that long, if he made that decision, I'm gonna have to go back and do some homework on that.
This last sentence here in step 3. Simultaneous with the board of directors notification need for second notice of violation, CPI, comma, upon the recommendation of ARC, comma, will forward the case to the GM. That probably should say in consultation with ARC,
Mhm.
not upon
Or
the
to even
recommendation.
take
of
ARC
ARC.
out of it.
Or take it out
Why
altogether.
does it need to be there?
Yeah,
Right.
I don't think
I
it
mean,
belongs
because
there.
if
And
you-
I think they need to stop taking it to ARC.
Right.
But I think I need to talk to Linda Martin, who has been the manager director of ARC or of CPI for ages, and kind of get the history on this.
There's a difference between going to them and saying, hey, could you just look at this, make sure I'm not crazy here? And ARC look at that and go, yeah, we think you're right. There's a difference
Yeah.
between that and codifying that
Yeah,
into a document that mandates it.
yeah.
Right.
Well, and I think in practice, we don't have enough inspectors. So the ARC members, in the course of their duties, going out to check on permitting issues, variance requests, setback, building setback, backline requests, that kind of thing. They're going out and looking at properties. In the process of doing that, they're aware of all these violations, and
Yeah.
they'll go back and tell ARC, yep, that violation is still there.
Or
Is that
go
the
back and tell
job?
CPI.
Probably, I mean,
Yeah,
yeah,
CPI.
yeah,
Yeah, so just so we don't forget this particular element of it though, which is what Jim initially brought up in this paragraph A. Where we're talking about this notification will be delayed. I do think this paragraph needs some word tweaking.
yeah, it's not clear. You're absolutely right.
Yeah, I mean, one way to reword it would be the general manager will, after the date by which the responsible party must request an appeal hearing, notify OPA legal counsel. I mean, you could reword this to make it more clear, but as it stands now,
It's not,
it's not.
that's where I got confused.
Yeah.
Why
It took me a minute to understand what the point was, but I agree. That paragraph needs to be reworded, I think.
but the bringing ARP in, which isn't really related, I understand they can consult with them. That's different.
All day
They're out in
long.
the area, please give me
All day long,
feedback.
right?
But that doesn't necessarily have to be part of the procedure. They can get anybody to go out and look at it.
Right.
Right.
They can ask you to go out and look at the property and see what you think about it.
Right.
Exactly. Yeah, and I think that's in practice what's happening,
Yeah.
but somehow ARC, I don't know,
Yeah.
and that all happened
There's a
before
lot.
I became liaison.
So our
Right.
position as a committee could be, even though this isn't a conflict necessarily, it appears to be establishing a new requirement as worded, which is tasking ARC to do something which previously was not codified.
Uh-huh.
And making sure that everybody understands that that's how this is being perceived. And certainly, if, again, back to your point, if the board wants to do that, then I guess the board can do whatever they want, right? But to Jim's point, as long as everybody understands, that's what it says, and that's what it means.
And that's
I don't
what
know
you're
that you-
referring.
I don't think you even have to go that far. CPI is under the general manager. That's operation, that's not policy. So if we don't touch the policy, you just take ARC out of that step 3 paragraph entirely. Then it's CPI dealing in operations.
Right.
So I think that's really all you need to do.
Yeah.
Was it just that paragraph?
That's the
Well,
only
there might be other
place I
places.
can.
I'm just
I
focusing.
looked through the whole document and that is really the only place.
Oh, well, then that's an easy fix.
Yeah, I don't think you have to
Well,
get
it's
into whether
easier
the
s-
board does something, doesn't do.
But in practice.
CPI's
Right,
rests
right.
they're
under
doing-
operations, that's the general manager's ambit. That's his umbrella.
Yeah,
But whether they're voluntarily assisting CPI is not the same thing as being formally tasked with it in this document.
yeah. But the other question mark I have in my mind, and I probably shouldn't say this on tape, is this, again, being new to the ARC, I don't know how this has been going all the years that ARC has been grappling with these issues. But my hunch is that this senior inspector, who has not been an inspector that long, like to rely on somebody else to kind of firm that final call that this is a violation. I'd have to check on that.
Sort of feeling its way along.
Yeah, and that it's affirming. He's a
Yeah.
young guy. He's got all these gray-haired people in the room. They're all willing to say, yes, we'll go out and look at it. And they'll look at it and they will affirm. I don't know if that's what's going on, but I wonder.
Yeah,
And so I can, again, I think I need to go back and talk to Linda and find out how this actually, does this really represent what's been happening? And
well, not
if
just
so, there are parts of it that are not consistent with our property.
right, right.
Yeah.
Right.
Go ahead.
No, I was gonna say, I let me well be right, that's. And if the new inspector wanted to do that, that's fine too. The question I have, I'm gonna put it to Jim, but if you look at CPI as just being under the ambit of the general manager, then you don't have to get into the other policy questions you raised, which is permitting versus other functions.
Well, no, that's not really my basic concern. My basic concern is we understand that nothing's gonna happen. Unless the general manager has a notification in his hand, he says, well, heck, I can fix this. $1.95 charge and we'll go out and take care of it. Unless the general manager is gonna come to the board with a proposal to clear a violation, which I think is not a very common situation, because I don't think one of those occurred in any recent meeting at all. But unless the under what's in here, unless the general manager comes to the board and says, we can take care of this by doing such and such, the hearing must be held or scheduled and nobody shows. The hearing process must be complete before you begin any kind of compliance activity at all. But that's what that says.
That's what A says.
That's what it says. Unless the general manager is going to come to the board and say, I can fix it, the general manager can't do anything until the hearing process, meeting held or not held, is complete. And then the board says, okay, GM, go.
Yeah, that's how I read
That's
it.
exactly the way it's written.
Yeah.
It's right.
Again, I may sound like I'm saying that's not a good idea. Maybe personally I feel it isn't, but my point is, I think that needs to be understood what it means. And there may be some silence here means that there is some question about that.
Well, it may just be the way this is written, because, again, go back to step 3. You deal with the first notice of violation. And it says violation is not corrected, or substantial progress has not been made correcting the violation within 15 days from the date of the notice. Then CPI notifies the board and the GM gets involved. I think maybe those 2 steps would need to be broken out separately.
Well, actually, Jim, I think the way it stands before the change of law,
Yeah,
the second notice of violation always went out before it went to legal. What changed is that the law now says that the second notice of violation has to come from the board, because that notice has to inform the property owner that if compliance is not achieved, they may be subject to restriction of their property or their membership rights. And so all of that has to happen, and that kicks in a time frame by which the property owner can decide, am I going to request a hearing or not? So you have to wait until that 15 days, I think it is, goes by before you can go to the next step. And the next step would be, okay, they don't want a hearing, we can go ahead and send it to legal, we can impose or other sanctions. If they want a hearing, they get their hearing, I guess, before it goes to legal.
That's what, yeah, that's the way it's written now.
Yeah, and I think that's the way it's meant
Draft.
to be written, but I'll
Okay.
double check with them.
Okay.
Okay, I
The
got
the
got it
current
in writing.
process is the CPI sent out a notice and gives them X number of days to, 30 days, I believe, to respond. And then when there's no response or unsatisfactory response, they're advised that they can go to the ARC for waivers, variants, and whatever else it says in the resolution. When that process is finished and there's no completion, it goes to the general manager. And the general manager is to go to the legal at the same time as advising the board that he has this variation or violation rather. So the current resolution goes through the general manager, from the general manager to the attorney, with notification to the board that he's gone to the attorney, or come to the board and say, I can fix it. So the general manager is now, in the current resolution, is the pivot point.
Yes,
In the draft, the board is the pivot point.
okay. And actually, my understanding is that nothing goes to legal until the board votes on it.
Well, that's what
Yeah.
the draft says.
Yeah.
Yeah.
And that,
I-
and that's currently happening, that before this law ever got changed, any referral to legal had to be approved by the board to go to legal. It's a pretty pro forma process,
Well, but
but
okay, in the last 4 months, that's the reason why I say 4 months. Because I've reviewed the board meeting part of CPI violations in the last 4 months. In the last 4 months, has any violation gone from the association to legal?
no, because we don't have the due process in place for implementation of this law. And that, I think, is one of the reasons that ARC got involved with this, because the inspector was frustrated that he's going out. We have a backlog of probably 60 continuing violations that need second notices.
Okay,
And he's frustrated. They were frustrated that the board didn't seem to want to take any action on how do we implement the change of this law? How does this affect us as ARC? How does it affect CPI? How does it affect this process? And so, my advice to them was they were updating the MO1. I said, well, put in MO1, what you think
okay.
needs to be done, and put it on the board's
Okay.
plate.
Okay. The understanding, whether from legal, from council or not, the understanding is that with the code provision in place, the code provision in place deals with penalties to the member for violation. But it's not simply penalties to the member of violation. It's use of the compliance provisions of legal course compliance. The DRs allow that.
Excuse me, say that again. The DRs allow.
The DRs allow the association to pursue compliance with DR provisions through legal judicial means.
Yes,
But what's we, the board, we, the council, or some combination are interpreting the passage of this code provision to mean that it's not simply not violation, sanctions under the government documents that cannot be pursued. It's legal action cannot be pursued.
and that's
And that's,
The board is not buying into that interpretation.
well, I'm saying that's what is the interpretation.
Yeah,
The interpretation you're giving me is the code provision, code provision that we're talking about here. Says that you cannot proceed with any compliance action until after you have the hearing process. You cannot, in particular, you cannot proceed to the attorney unless you go through the hearing process.
that's what this says.
That's what he said.
That's what this says. But
Yes,
is that what the code, is that
Yeah,
what
that
the
isn't
legal
what the code says.
interpretation?
that isn't what the code.
That's what 8 says.
Okay,
That's what paragraph 8 says.
Yes. Yeah, because
All right, so what?
well, yes and no. That doesn't say that after it can go to legal regardless of the outcome of the hearing process. So say these,
That's not what the.
That's not what it says, because it says, and so this goes back to its very original question. Is that what you meant to say? So it says general manager will notify council.
Mhm.
Then the next sentence says notification will be delayed. Now, is it the same notification we just talked about?
yeah, and that's unclear.
Right, that's unclear, because the strict interpretation of that would be that yes, this notification we just mentioned will be delayed. Or is this a different notification we're talking about? So that was, I think, his very first point when he brought this up, because if you read it as it stands, you can't go to the legal counsel until after the whole hearing and appeals process is done.
So what would you change?
I'm not gonna get into.
We need to come to some kind of fruition here, your
I think
conclusion on this topic. So that, is there something that we need to be voting on today about this? But it sounds like we still have too many questions to do that.
And
So it
it's not
sounds
fair.
like, unfortunately, we gotta take it back to
Yeah.
you and your.
And I think what it really means is that I need to have a conversation with our legal counsel.
Right.
Because, which I've been trying to do for 6 months, believe me. When I was president, it's probably more than 6 months. I've been trying to have a conversation with him about this. And he's ghosting me or whatever. I don't know what you call it, but I've not been able to get that conversation. And so, and nobody, correct me if I'm wrong, I don't see anybody else on the board who feels that this even needs to be addressed.
Well,
That it only becomes a problem when the first person asks for a hearing.
Well, I think that's right.
That's pretty much what
I
I've been
think
told. That we do things the way we've always done them until the first person asks for a hearing.
or
Somebody throws a punch.
or some property owner who has been complaining to the board about a violation that has never gone to court, takes the board to court. Then it's going to be another lawsuit that we don't need.
Sure. So.
But
let
as
me
a
just-
property owner,
You're
as a
preaching to
property
the
owner, I
choir.
want it fixed. If I were on the art committee, I sure as hell want to do.
Yeah,
They want to get their job
frustrated.
done. Why be on a committee that?
So
They're very
wait a minute. One of the things we talked about at the last meeting was the fact that we can give the board an advisory, even if they haven't given us our charging document. And on that advisory, you have to put down the risk. The board needs to know what the risk is. If they vote on it, vote it down, that's their problem. But we've provided the risk information for them to make a good decision. And we can talk about this forever, but it still has to be changed, to Jim's point. And you have to go back to the committee, and the board has to understand the risk it takes.
Yeah.
It's because we're the ones interpreting the bylaws and the DRs.
Our job is to just make sure we're not violating any of the legal documents and to tell the board accordingly. And if the board chooses not to act, then it's the board's responsibility.
So I think to Pam's point, right now, to put a period at the end of the sentence for today, because it's now after.
We still have
so
other stuff.
Yeah,
to do.
it's gonna take too much.
I see two things, basically. One is should ARC be in this document?
Right, yeah.
That's one thing.
Uh-huh.
And then the other issue is this paragraph A and the implications of the way it's written. Seems to me that's our feedback, right?
Right.
That we feel this needs to go back to ARC with these two questions.
Right.
Is it appropriate for ARC to be in here, inserting themselves as a required part of the process? And is the way A is written, we think it's potentially not in compliance with
The new law.
the new law.
Correct.
Yeah, I think if you break 3 down, so that you deal only with what is available to do in the first violation. And then you come to the point where it says if the, what do we call it, the homeowner, lot owner, whatever, fails to make substantial progress, remedy the problem, or
Any of them.
yeah, whatever, for $1.98, we could fix it for you, that sort of thing. You know, send them a roll of duct tape. Until that's resolved, you don't get into this whole thing about sending the second notice of violation to the board and you have to break the first violation and the steps taken out separately, and then another step goes to the second violation. I think if you draft it that way, it would make a little bit more sense. I think that, did I get that right?
Yeah, I think so.
Okay.
One quick final comment. We were talking about what the code can, what you can or cannot do under the code. In January, we sent 6 cases to circuit court. If the code provision said that we couldn't do that without having the hearing first, we shouldn't have been able to do that.
Those were 3 years old.
Yeah.
With the new law.
Those were violations,
The
and
law-
I think the new law applies to violations identified after October 1st. So all the old stuff,
Okay.
we are backlogged 3 years, since before COVID.
Yeah. Look at property owners that have to live with that. And
So
that's
we-
why they bought into a condo.
As a committee, that we're sending this back to
Yeah.
ARC with
Correct,
these
Yes.
at a minimum, with these 2 basic issues that need to be
Correct. Yeah.
addressed.
Yeah,
And
I think the hearing part needs to be
the
added.
hearing time.
Okay, these
and-
And I think what Steve just said, if you break it into 2 pieces, first violation, it's not
Yes.
resolved, and then go into the second.
Yeah, I think that would help.
That would help make it clear. That would solve my,
and so I think I have a clear understanding. Do you want me to articulate what I'm gonna go back with, or just trust me?
I trust
Is that
you.
all right?
Would it
I
make you
fear it
more
will lead to more
comfortable to
discussion.
articulate it?
you
Um,
lived with this when you were chair of this committee or the liaison.
Well, I think I
Jim, if
think
you
I
want a consultant
got it.
contract, contact ARC.
that alleged violation language calls into question in the new statute, calls into question what the hearing is meant to decide. Is it meant to decide whether there is a true violation or not? Or is it meant to decide whether sanctions should be imposed
The
or not?
consequences
Yeah.
of such a violation.
And including sanctions of sending it to legal. So the sanctions that, if it's sanctions only or sanctions plus violation, is legal included in that? Or is it just the violation of rights? And then the other piece is the articulating steps 1 and 2. And then taking the ARC authority means that they don't belong in here,
Yeah,
in those steps, that process. Okay, so I got it.
yes.
What do you mean by sanction?
The going to legal for an injunctive, whatever the legal does when they go to court. And the other one is the restriction on violation on property rights
I would just say,
or membership rights.
the question is it confirming the violation and or the consequences of the violation?
Yes, but Jim also raises a question as to, we've always had the consequence of sending it to legal. Now, the law doesn't speak to sending it to legal, but it does speak to restricting property owner rights.
Hmm.
Do we now sweep that other consequence into this,
I got that.
or is that separate? So, and that's a question, I think, for our general counsel. So,
Oh, that's, okay.
yet again.
As
I
to
will
whether or not
be
you
beating
wrote
my head
statements,
against
some
the
of those
law.
general counsel, that.
Yes, thank you so much. You guys are so great, and I apologize.
An honorary member of our board committee is spending some.
Bring you and Jim to all the meetings.
You don't want me ever to come back, but as of August, I won't be back. I guarantee you.
You
So
can come sit with Jim. And, we'll have our little audience of retirees over here.
The
I need
expert,
Yes, the expert panel.
expert panel.
Yeah, yeah. Okay, so now, Steve, please help me with refreshing my memory now. What's the next one that Doug wanted us to talk with?
Yeah.
Because, well, I guess this is a twofold comment, so, we are not scheduled to have another meeting before the April
Right.
board directors meeting,
Right.
you know what I mean? Because today's meeting is so-called our monthly one for April. We don't technically have another one until May 12th, you know? I would be fine if we don't do this, but do you feel we're gonna have to throw in another one, sometime before the, April directors meeting?
We've got a lot of things on unfinished business.
Because,
Well,
Can I just, maybe short circuit this a little bit? Let me backtrack a little bit. Yesterday, I got a series of emails, which I've shared with Laura. She's my contact to the committee, from Doug, dealing with, 3 separate matters, and I think we can dispose of them hopefully fairly quickly. As to B02, which are the rules of order for meetings of the Board of Directors. This is not our annual meeting or everything. This is only here for the Board of Directors.
okay,
Under for C, public comments. Doug is asking that it come back to the board to ratify the following. This is under eligibility. Any member who desires to address the meeting during public comments shall be recognized, period. And then insert, members must attend the meeting in person to make public comment. When beginning comments, members shall state their name and address. So the only thing he wants to have, he's requesting that be inserted is members must attend the meeting in person to make public comment. Now that differs to some degree because we do allow members to view the meeting. A few teams,
so this would be specifically for
public
regular monthly board of director meetings,
correct.
not the annual meeting.
Well, and not just regular, any meeting of the board would be governed by this, not until the board closes the meeting for reasons that are allowed under the statute.
So this would include the annual meeting.
No. The annual meeting is not a board meeting. The annual
Okay.
meeting is a members meeting. The title of B02 is Rules of Order for Meeting of the Board of Directors. Okay. So what I'm saying to you is there's one sentence that he wants included under public comments that would make you eligible to make a public comment. That is, you must attend the meeting in person to make a public comment. That's
So not remotely via.
not remotely. Now, let me, again, prior to I want to say the November meeting, maybe the December, I can't quite remember. At least when the meetings that I attended, and even after I got on the board, after people who were present made comments, there was a call to Josh, who was operating the team's operation there, and said, "Is there anyone, Josh? Is there anyone on Teams who wants to make a public comment?" Best of my knowledge, I don't think anybody ever did. But that's not that. Don't take that as gospel. That's my recollection. But anyway, so we do allow people to view the meetings through Teams.
Right.
The only time the public has an opportunity to comment is in the public comment section. This goes back to this was explained to us when I first got on the board, and that is the board meetings are essentially that. They are meetings for the board to transact business.
Right.
So the public has an opportunity to comment on anything that the board will do, because the public comments come first. But this would be a limitation because it would keep people who are on Teams making public comments. That's what he's looking for.
I
So I have the screen up.
I-
That's the original wording.
Yeah.
Okay.
I don't.
Nine.
Because, number one, I go to the board meeting. I don't want to listen to people that didn't take the time to come here complain. Come to the meeting and make your complaint formally.
I think you're leaving out people who might not be able to do
Well,
that.
before we had video, we didn't even need it. Eliminate the video then and let them come to the meeting.
I'm gonna tell you something that a 96-year-old man told me that I take for granted. That is, things change.
Okay, but he has the option of putting anything in writing and sending it to the board, so he can appeal to the board. It doesn't eliminate the right to appeal.
I just, my
comment.
position, the reason I don't have a problem with it is because I don't think there's a requirement. I don't think there's any requirement out there, that we even have the video to begin with. It's something that we just started because of COVID.
Right.
I mean, we recorded them before that and we posted them
We
online. So
recorded and
but
posted.
being able to actually watch them live. I
Take
think we
live,
only
right.
started
That's
for
new.
COVID. Yeah.
So
So
being, so I guess I'm trying to figure out, how a homeowner would look at that not being able to make a comment, even though they have some physical problems, some transportation problem, and we're allowing them to be watching, but they can't make any comment. It sounds like disenfranchised.
Well,
Well.
but
yes
if you
and no.
read the homeowners act, there's no requirement in there to even provide that. So when you bought into the property, you're buying with the homeowners act, the declaration of restrictions, bylaws, and everything else. It's a advantage that's given to people to be able to watch it real time.
Well, for example, I'll share with you in my old county, right, that I still have a home and I'm still participating with stuff. Our Board of Ed live streams like we're doing right now. Somebody could be, because our link is up on the calendar on the website, they could have joined us and been a guest, right? Could watch it. But our Board of Ed meetings, you can live stream it, watch it, or watch the recording later, but
Right.
there's no interaction on that end. Now, what they have done because of COVID, they allowed a phone-in option for someone to make a public comment. So, but most of the public comments are by people in person at the meeting, right then and there. But they did set up some way that they can call in and then, make their public comment. But it's through a phone system. It's not part of the actual live stream meeting, if that makes sense. You know what I mean? So it's not like I'd be on Teams and I turn my mic on and be able to say my comment then. It was something totally unrelated to that they called in and were able to verbally say. But I still think that even if you're physically unable to make a meeting, as Bob stated, we all know that every director has an email and there's a general information email address that's always out there. We have the opportunity to still voice your thoughts and opinions on anything by sending that kind of communication. It's just not verbally in front of everybody in a public forum format. You know what I mean? So we're not taking away an opportunity for someone to still say, hey, board, I don't agree with this, or I do agree with this, or whatever. They still have that opportunity, you know, even if you limit it to only people in person making a comment.
Well,
In the public comment section.
and I would just like, again, to, our position here on this committee
Right.
is, does that recommendation violate or is it in conflict with any other requirements that we have?
Right.
So in that respect, the answer is no. We may not necessarily like that. We may think that it's a restriction, and if it is, then as an individual, you could express that to the board, you can express that, you can write Doug Parks and say, hey, I heard you come up with this, I don't like it. But as a committee, our job is to say, does this conflict with anything else? Yeah, is this, and, you know, and so I think the answer to that is no, it's not, because we don't have anything in writing about it to start out with.
Just as a procedural matter, just so we're clear. This came up before the board as a charging document. Came to
Okay.
the board, committee sent this to the board as a charging document.
Which committee?
This committee, bylaws.
This, we send that to the bylaws?
This committee, like, I
Um,
do it, yeah. At the March meeting, it was, this is from Doug. At the March meeting, it was agreed that I would send a proposed change to resolution B02 regarding public comments. This went before the board at the March meeting because my signature here is March 7th. So this went up to the board on a charging document. My question is, or what I'm coming to the committee with is, does the committee, I would prepare a first reading to go back to the board as to if they want the change included. If it's not included, I'm not quite sure how I get it back up. Well, I guess back it off for motion. Anyway, what I'm inclined to do is do a first reading of B02. I can include the board, if the committee votes to approve it, I can include this sentence in red in the change to B02.
Right.
And as a first reading, bring it to the board and call it to their attention. So I need a vote from the committee, one way or the other.
Well, do we have a charging document? Because otherwise, what are we voting on?
There's a charging document that went from the committee to the board.
And what did our charging document didn't have that statement. In it.
Oh,
That's
an old
to review.
Yeah, this
That's
is-
to review.
This
is-
Okay,
This is
That's
over
different.
your Governing your.
Okay.
Your.
yeah, yeah,
This thing,
yeah,
June of 22,
right.
June of 22.
Yeah, that goes way back.
Yeah.
right,
Okay,
okay, and I got it in front of the board at the March meeting.
Got it.
I got it, I'm 9 months
Well-
behind schedule.
So in other words, he's good with whatever we submitted before with that charging
Plus
document.
this thing.
Plus this.
yeah.
So,
Okay.
so he is now writing back to me saying, what are you doing about this?
Gotcha.
And so
Okay.
I'm coming to the committee
Yeah,
and
up to
saying, do you
speed.
want
Now it makes sense.
vote? You want this in there or not? Because I'm
Yeah.
gonna bring it back to the board on the first reading.
Well, you know, the bottom line aside, stay away from the politics. There's no reason not to put that in. But
It's not a violation.
the question is, if you go to the board and you're at a meeting and you're going to make public comments, 90% of the time you never get an answer, nothing happens. If you write to the email address that's on the website that comes out every week, you always get an answer.
You get feedback.
So it's a better way of communicating and getting problems across. It just because everybody hears about it doesn't make it really any action going to take place.
Make a motion?
Yes, make a motion. Let's move on.
That we agree to this insertion of the sentence.
Augie, I didn't hear anything from you, but I make. You
Second.
okay? There you go. That's good.
Any further discussion?
None for me.
All in
No.
favor of approving just,
I,
I don't know how, yeah.
you got all,
Sentence,
Aye.
back to the liaison to take it back to the directors,
correct.
right?
And this will
Right.
be for a first reading or just? Second reading? Okay.
First reading?
Well, because I need a.
Okay, 'cause we made a change.
We need a month, and
Yeah,
then we do the second reading.
Okay,
Okay.
boom, done, next.
okay.
So I have to leave at 3 o'clock today.
Huh?
I'm taking care of a man who has dementia, and I can only leave him for 2 hours.
What's that?
Okay.
Problem.
Okay,
All right. What's the next priority?
B05, conflicts of interest.
Okay.
And I will preface it by saying both B05 and B06 at the board meeting in March were referred to council for comment and editing, for lack of a better term.
Okay.
That came back. You will note.
And this one's 5.
Oh, we got an answer?
There are various crossouts and changes and whatnot. I will tell you that council basically views these as, I think, more technical conforming changes. They, correct citations, and if you'll note, instead of saying Article 10th, it's supposed to be Article 9th. Instead of saying Article 3rd, it's supposed to be Article 7. I mean, and the text down below is somewhat different.
It's like a rewording.
Yeah.
basically.
Yeah,
The same
it's
as
right.
this.
And so
Yeah.
this is going to be the same question as I raised with you in B02, which is, these are now subject to, make sure I get this right, yes, to first readings. And I need the committee to vote on whether or not you accept legal's council's suggested edits for the purposes of bringing it back to the board for a first reading.
And the question is, does it conflict with any existing?
And I didn't
Well-
have time to email you guys these.
Yeah.
Oh, good. So
I'm
I
like,
can
oh
send
my
it back out.
Well, so my first question before we go here is, again, this is another one that we submitted last summer with red lines.
Right.
So is the assumption that the red lines we submitted were accepted? And this is in addition to those red lines?
With the way I read this is if it's crossed out, those are edits made by council. If it's an addition, as you look down at paragraph 3B, that's an additional sentence that probably was not there before. Let me see if I can prove, make sure that's correct. Yeah, if you look at what I submitted in the first reading, 3B is only that first sentence. No director, officer, employee, committee member using confidential and receiving course association duties to benefit any person, company, corporation, or proprietorship. There's a sentence in red that is added, not crossed out. No director, officer, employee, committee member shall disclose confidential association business or information outside the board of directors without prior approval of the board of directors, or except as otherwise permitted or necessary in working with the association's legal counsel.
Yeah, that's legal talk.
We're on B05, B06 simply request for review. And then apparently it went to council and everything has been read, council, is that right?
That would be correct, yes.
Okay, so what's being asked of the committee
Endorse with the council.
for first readings, go back to the board.
Right, right. I mean, I have to bring, my view is, somebody tell me if I'm wrong. My view is, in order to get these changes that are part of this form done, it has to go through a first reading,
Right.
and then a month later, I can bring it back for a motion to approve.
Right.
When it came up as a charging document, both B05 and B06 were referred to council. So what we now have is council's edits to what was presented to the board in the charging document. In our charging document is somewhat aged, but aging's good. Like a good wine. It's not-
Why does my brain not
Yes.
like the way it's written? When it says Article 7, shouldn't it say like 7th article? Because to me, it should say Article 7 not 7th, but, you know,
Seventh is,
I think it's,
I think that's the,
seventh is the term. in the-
it's a term of art.
okay.
So I think that's the correct way to.
Since
It
that
doesn't
includes,
sound right to me, but,
since,
so this one-
since that includes all of the recommended legal language from our council, I see no reason not to make a motion to approve it.
So you all know, this one is B6 that I have up there, and that's what they would have changed, the cross outs and the, you know.
Oh, is that-
We spent a lot of money for their information.
Right.
I would go with it.
Wait,
Yeah.
you're in five, you're in
want
6,
five?
I'm still
Yeah.
at 5.
Right, here's 5.
So
But same
are
difference.
you making a motion?
I make a motion to approve it as submitted by the legal attorneys.
Second,
Any further discussion on
None for me.
5's recommendations? All right, all in favor, please say aye.
Aye.
Augie?
Just think if you may actually get some of your items off the worksheet.
B05, he is.
He's okay.
Yeah.
Okay, good.
Yeah.
All right, B06.
B06.
We don't lose any. Okay, B06, indemnification policy. Now, this is again, the same situation. Came up before the board under a charging document. Doug recommended, board agreed, refer to council. Council has returned B06 with edits, which you'll see. Are, again, I think they're more technically conforming, but they're either additions or where there's a cross out and then something underscored. That would be an edit as opposed to an addition.
I like to ask for current volunteers.
Should maybe. And so the request is again the same. I need a vote by the committee as to bringing it back to the board
This one.
for a first reading.
Yeah.
Motion to approve as submitted by legal counsel.
Second.
Any further discussion? All in favor of approving B06 as presented, please say aye.
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 Any opposed? All right, thank you very much.
Okay,
we're moving right along.
We're actually accomplishing
We
something.
spent the first second and a half. on
okay,
that.
we're good to go. Okay, as far as I know, that is really about all I have.
Priority
To
ones
clean
for
up.
our April meeting.
Okay,
I'm done sweeping up after the parade, yes.
Okay.
yeah.
That's my priority here is just to, if we're not adding any more meetings in prior to their April meeting, have we accomplished everything that you need for that?
That I was charged with yesterday, yes.
Yeah.
I will tell the committee it is, unless I'm, and I'll seek counter advice from Doug and others on the board. But it'd be my intention to bring up the proposed B09 video recordings and retention policy up in April under a motion to approve it, even though
Well, Doug,
Laura's concerns notwithstanding. I don't know whether or not that has
Well-
that's sufficient to for
Well-
the board to act, but I
Doug's,
understand the concern.
didn't Doug send that to the board? I mean, to the attorneys? Because he had questions. I rewatched the video
Oh,
and I,
It's forwarded- Yeah, it says forwarded to council for review.
He
yeah,
finds it riveting.
B09
Yeah.
went for
Yeah.
review.
yeah.
Oh, I'm sorry. Then
I went for legal review because he was concerned about retention for videos and bars and stuff like that. Yeah, so that's where that one is at.
Okay, now
Yeah,
I
so
will
for-
tell you that I saw it, I didn't read it that closely, because to me it didn't reflect the other stuff. There was an email from Jeremy saying he didn't see a conflict, but I thought we may have been talking about something else, so let me just tell the committee there is a chance I will bring it before the board
Okay,
on a motion. I don't know for sure. I'll get that cleared up on my own,
okay.
Okay.
but I'll check on that.
His reply.
And by the way, I rewatched the video and your voice was on the entire time that you were addressing the board, so
Because we know where to put the microphone.
I know,
Oh,
I understand.
And I do have 2 other charging documents that I guess I've come into possession of,
Okay,
dealing with F04 delinquent assessments. And F01 dealing with investment guidelines.
And what is their background on those from the board? Why is it coming?
No, this is from us to the board.
Okay, us to-
Asking for them to approve,
Yeah, this again is sort of our older ones.
review or approve.
Those are ones that you had put on hold as low priority pending some of these other issues.
Right,
Right.
and I think part of it was I was trying to get through not being
Yeah.
there in
Yeah,
February and then loading up for March, and so now these are two more that I'm coming up with.
okay.
I'm just reading the charging document, F04, the resolution due for review in May of 2022. Noted that paragraph 3A6 of the resolution requires review of the effectiveness of the assessment collection effort provided by to the board. There's no indication the board means this review has been accomplished in 2022. So it's, I guess, supposed to be a report on how we're doing with collecting assessments,
Yeah.
which is probably worthwhile information. F01 investment guidelines currently due for review. Review this resolution is scheduled for every 2 years. I don't see a review date on this.
So last summer, we submitted red lines on that with the charging document.
Going back to Laura's point, we can go look at the video now
Looks like
because
it
it's
was-
there.
The resolution itself was approved in 2016.
Right.
Committee suggests consideration given to the following provisions in particular. Degree of specificity, I'm sorry, paragraph 2A degree of specificity, is the degree of specificity currently necessary? 2D, are the requirements of approval, review, and reporting findings currently in effect? And 2C is delegation of investment authority currently in effect.
If I'm not mistaken, those were actually brought up at a meeting of this committee.
Okay.
What's the date on that?
6/20.
The charging document is dated June 17th, 2022. And it looks like Laura, I guess, got it to me on June 13th. I haven't signed off on anything yet. So
Those are ones that were previously submitted and never acted on.
Those are some of your comments on that.
Yeah, those were, they're just old. We sent it up as a charging document. Nothing ever, it just sort of
Nothing
died. So those are just,
so
So
it
either-
died in the interim between the election and the new.
yeah.
Board liaison.
committee and the new
The board just got overwhelmed with stuff and they
Okay,
just
all right.
sort of
So
died.
All right, so this, I'll take these up as
New.
charging.
First reading.
documents. Unless, I'll ask Doug whether he would prefer me to do because there was a brief discussion about this at the March board meeting. I'll ask him whether or not he would prefer these to come up as first readings or charging documents. My reading is this would be appropriate as a charging document because it's the board that has to decide. But
Well, yeah, because some of those are kind of open into questions.
Right.
So essentially they need to read those and go, yeah, we agree it's an issue, send it back to us,
okay,
and then we can tweak up some language for them.
all right. I'll take them up as charging
Be a
documents.
cricket
Okay.
around here somewhere.
Best of my knowledge, that's all I got.
Oh, is it?
So on our agenda, under old business, I think all we really have today left to do is this convenience fee resolution. And according to your notes, you said the board sent it back to us for further work. What do they want us to do?
What do they want us to do?
Which one? Oh, the review.
Review the convenience fee resolution, you know, the unknown mystery resolution that I asked.
I thought, just a minute. Here, just a minute. You have sent back to the board. If you
But we haven't.
review the minutes of the meeting, the board meeting, Doug basically said it belonged it didn't belong in the policy. Did he say policy or procedures manual? But anyway,
I have them, I just wrote on when I was doing this, I jotted down real quick operations, which would mean.
Yeah.
That's what I
the operations, right?
I'll go look at the minutes again, at the video again. I actually thought he said, budget and finance should take a look at it.
No, maybe.
Oh,
Yeah.
all right, that makes more
I
sense.
could be wrong, so let me
So I'm
look at
gonna-
the
And
minutes.
like I said, I'm just trying to hear it from in the room too, and honestly, sometimes I need to go back and rewatch the meeting because
Yeah.
I can't hear.
Doug sent it someplace else, not back to our committee.
Right, if it
I'm
don't-
trying to remember, read my own notes now. I went and watched it and
I'll
wrote
look,
notes.
I'll look at the video again,
Okay.
then I will send something to you,
Okay,
and you can tell the committee.
Okay.
That's sort of the way. it's
that's fine.
It's at
Yep.
2 hours and 13 minutes if you want to look at it.
Yeah.
Oh.
That's it.
No, I want to watch it all over again because I had so much fun the first time.
And Laura told me
I
when
don't
I came to the
understand why
meeting, she said,
anybody
this
would-
is gonna be riveting.
Yeah.
That's my word for our group. is
That's
We are
like-
riveting.
Driving a rivet in.
Yeah.
Okay, all right, I'll take a look at it.
I'm very impressed with our progress.
Okay.
So I think that brings us up to new business M9, because we discussed M1.
Because everything else,
M1 is done. M9,
M9, they're
There's nothing
putting
we can
together, no, they're putting together a search committee.
a month late, 2
Well,
months.
that's not my issue.
Are they?
I
I just saw an article on the wet ocean pines for this week that they're looking for committee members. And I know at the last meeting, they turned down an application that wanted to be chair of that committee. So they have no committee.
I have just one question
well,
about that.
there's still the old dates, and I'm still confused about the dates under the search committee. This is the search committee's
Yeah,
thing.
it's updated.
They have 2 people listed on there with expirations of next year and the year after that.
No,
Is that just because when they went in, it automatically bumps it 3 years, even though this particular committee, the search one is supposed to be 1 year at a time?
Somebody just went,
I think,
application.
Yeah.
Approval dates and reach C01,
Right.
term,
Okay.
term length.
But it
I
makes
think-
it sound like they're
Yeah.
current members and,
They are.
first term, second term is listed on there and,
I believe that one of them has indicated they don't
That
have
they
a
don't
desire
want
to
to.
serve anymore if they were asked,
right.
but I don't hold me to that.
Well,
Yeah.
so just to review here, according to my notes, actually, I think Bob, these were your notes at the time. September of last year,
right.
new board liaison to review recent changes in the bylaws at a board meeting that necessitate changes to this resolution in order to obtain consistency with the bylaws. So we had a change to the bylaws. They got approved. And I don't remember, quite frankly, off the top of my head now, but apparently they impacted this.
Right.
This resolution in some fashion. So, but I don't have in the notes here that a charging document was created by anybody to do anything about it. So does anybody remember what the changes were? It should have
Well, do you remember the
remember
board,
charging
the board of
document?
directors said they want to get rid of the search committee?
No. I don't think the board ever did that. I think there was a discussion
The
Okay,
search
About the
committee itself
future of
said
the-
they recommended
about the
that.
future of the search committee.
We tried to eliminate the search
Do
committee.
you remember, Jim, what the
But
change?
you
in the
can't
bylaws
do it
turned
because
down.
because you got the bylaws. It's
There
in
is
the
a charging document?
Dated June 10th.
Oh,
Which number is
I
it?
can go,
To be honest about it, at this point, this is more my opinion than anything else, but whether or not the search committee continues to exist or not is really beside the point, because I believe under the bylaws, there are certain tasks assigned to the search committee that they should be doing right now.
Yeah.
And
Right.
so, unless we address the bylaws, and maybe even M09, we can't just vote to eliminate the search committee right now.
no,
yeah, I don't think that.
we had to turn down. That was.
Yeah. I
It's a
think for-
bylaw thing, so we can't, the committee can't do it and the board can't do it. The members have to do it.
Right, I don't even think that's for us to worry about. I think for us to worry about is there something in M9 that conflicts with the new bylaws changes? And if so, M9 needs to be updated to whatever the bylaw says.
Yeah. We need to get it, look at it.
And it
Which number
Well,
is this one again?
should be
Which one does this apply to?
in
M09.
M9.
And as.
You get that look in your face, Jim, like you're
Well-
recalling something.
part of what we discussed
Right there you go.
before the, there's,
Wait a minute.
I will
Here's
point out to
This one's the M09.
Approve multiple provisions regarding work candidate qualifications for place on the ballot. Committee has noted public provision altered or on the search committee, application secretary, assistant, responsibility of the secretary. So there's a bunch of things apparently in M09 that now potentially conflict with
and
the bylaw.
and one of them is going to be the application itself.
Yes.
Which may be the most important one.
Right. I think that's the most important one of all right now.
Laura, will you email me that charging document?
There's two basic considerations that Steve just alluded to. Anyway, one is the text of the document itself in 09. And without a search committee, the text part of M09 is almost irrelevant as far as being unchanged at this time. But the second part of that, and it is part of M09, is the application itself.
And
The
that's
application itself is not accurate to today's.
Yes.
right. There's three of them and they're all wrong.
the Basic
Three of them?
text.
Yeah.
The
Three
application
applications.
Three. Which one do you want?
is an attachment, and that makes it a part of the resolution.
Right.
The text of the document without an existing functioning committee, the changing it is not particularly important at this point in time. The application form is a different story. And as far as the committee as it's shown on the website, that needs to be deleted. I don't know who wants to take an action on that, but there is no committee now.
Well, The
Wait, didn't we?
committee is one issue, but the other issue is the application is wrong. It's not in compliance with the bylaws. And therefore, we should get something to the board telling them that it's not in compliance with the bylaws and it opens us up for liability.
I think it's actually a subject that Steve is already broaching to some extent with the board. So now you just have a charging document to go with your discussion.
Yeah,
right?
I think we should.
Potentially, I think that's true. Let me backtrack just a little bit. In part, I think because of Jim's comments, Bob's comments, and also what I sort of found on my own, there are at the moment 3 different candidate applications floating around in the ether of ocean pump, for lack of a better description. One on M09 is, I think it's fair to say, the old application,
Correct.
which really is not at all usable based upon the bylaws. There is a second application, which I believe was used or was drafted by council without it being used, I don't remember which. Since the change in the bylaws had not yet taken place, the questions, I think I have this somewhere. Yeah, the questions in section 2 of the application were marked as your responses are optional or your answers are optional, something like that. That's the second one that's floating, and that is on our website under the board of directors. If you scroll all the way down, there's a candidate application, and that's the one that appears there. There's a third one that the elections committee has put out in addition to their dates that they have set for the election for this year, which strikes the sentence about the responses are being optional. The problem with both of these two applications is that it includes questions that are not part of the bylaws.
Right.
And omit and never had one question which is part of the bylaws. There's nothing in the bylaws that makes responses to those questions optional. You either are eligible or you're not eligible. There's no 2 ways about it.
Right.
So with some assistance from someone who will remain anonymous, I was able to revise the application. Sorry about that. I was able to revise the application so that the 5 criteria for eligibility are included in the application without the optional provision being in there. And then at a later date, either this committee or the search committee or the election. I don't know who would do it. But if they wanted to review this to solicit additional information that is not required, but might be helpful to people who are going to vote, we could go through that process, but that's not on the table right now.
Well,
So that, and the only other thing I would say to you is there in the application under 4, which had some dates in there, I did not bother to check the dates. I don't know if the dates are good or not. I'll leave that to the election.
Yeah.
So that's where we are.
So it seems like since we have a charging document already.
right. We don't have one.
We
do
have a concern. Yeah, we have this charging document already that says this resolution does not match the bylaws.
Okay.
So there's already a tasking out there that has to be addressed in some form.
Okay.
You've already started the discussion about this. Now you have a charging document to go with it. It seems to me.
With that as an attachment.
Yeah.
With that as an attachment.
Yeah.
I'll tell you. Okay. If you will send me the charging document, Laura.
Yeah.
I'll be there.
Okay.
So.
Yeah, I think that's the best way to do it. And that way,
Document for M09.
09.
Okay, actually I got that note down. All right.
That's
Am I
probably
sending
from,
you anything else?
probably from June of last year. The date at the top
Okay.
would be, I think
Okay.
probably.
yeah, because you, 3 different ones out there. We need to, do we need a motion for that?
I don't think
Is the
so,
charging
because
document
really,
already
because
there?
we already did this.
Right.
Well, what we did was we said there's a problem that needs to be addressed.
Right.
That's what we said.
Right.
Now, what he has today is he has a draft recommendation of how to address it.
Right.
So I guess the question is, do we as a board need to look at that? Or I'm not the
Committee.
board, as a committee need to look at that in order for you to take it to the board? Or is he just going to the board
Well,
and getting the board to agree that we as a committee should be working on this
Well,
draft?
here's the problem we're gonna face. Board's not gonna meet till April.
right.
The applications have to be in by sometime in May.
Beginning of May, I think.
Why don't we
I forget
just,
the exact dates, but the applications by the candidates themselves are due sometime in May.
Right.
So the problem we've got is a time constraint. Because I think we can all agree that all 3 of the applications are someplace on our website
are wrong?
are all wrong.
Right.
Because they're in some way, shape or form in conflict with the bylaws.
Correct.
So I don't know what the charging document says, but I am willing to accept the fact that the charging document says something along the lines of resolution N09 is not in compliance with the new bylaws. I can fiddle faddle through, the stuff that we don't have to worry about, but try to get the application addressed specifically.
Yeah, I mean, it's actually, the charging document's more than that. It goes into some of the language in the resolution,
Right.
which was kind of to Jim's point, that it's more specific to the search committee
Mhm.
execution. I agree that the application is the most important part of this issue right now.
There's no question there. We all agree with that.
Yeah.
Well, the other way to do it would
Has
be,
anybody pulled an application and submitted one yet? Do we know?
I don't know, because
Because.
Part of the-
what
part of
you
the question
do
is-
then-
They can
who
reach,
gets the application at this point? There's no search.
Well, well, that and what happens if somebody has already said they know they want to run, they've gone on doing some searching on the website and so they take one, complete it. Are we going to be able to give them an opportunity to resubmit?
I
a
think
new
you
one,
have to give them,
They have-
Right?
yeah,
you have to
they
give them the
have.
opportunity to resubmit.
Here's.
So everybody
here's what-
does the same.
Here's what my suggestion might be.
Okay.
Laura, if you want to craft a new charging document. And just point out that, I don't really care how you word it, but there are questions regarding N09 and the future construction of this or construct of the search committee, whatever you want to say. But basically say that there are conflicting applications for board candidates on various parts of Ocean Pines website, none of which are conforming with our bylaws.
They're actually different forms on the website.
Yeah,
Oh, yeah, three of them.
Well, I'm not sure about the elections committee. I believe the elections committee form is on the website under the elections committee.
It's,
I think that's.
it's there under the election
Okay,
committee,
yeah.
and they took out the statement that they were
Right.
not
And
required.
by the way, again, I had a brief conversation with Tom Piatti about this at the volunteers dinner. I just said, you know, we got a problem with the application form. There's too many floating around and we're not in compliance with the bylaws. I sent my suggested edits to the board and I CC Tom Piatti, but I haven't heard back from anybody.
Can we get a copy of yours? Maybe we can go out and get a couple copies made and look at them right now.
I would also like it noted that under elections committee, under minutes, the last minute.
You're satisfied with it, that should be the document we want, make it an attachment.
November of 2023. We haven't hit that one yet. They meant that should be labeled November 22nd, 2022. But their recent one's not
He's-
there.
But if we attach that, his charging document, that would, as an interim, it could be, we could recommend they approve it at the board meeting to use it for this election and then take time to resolve the rest of the issues
But I
later.
don't see an application under their committee,
Where?
under elections.
You don't go, there's three places that I found. If you go to the newsletter that they send out weekly and click on that, you will get this one, which is the old one without the statement, red line statement that says these options are voluntary or whatever it is.
Part of the problem is I can't get a copy to Auggie.
Huh?
I can't get a copy to Auggie. Of the revised application.
Oh,
Well, I can. Do I have that?
I think maybe I didn't send it to you because I wasn't sure.
If you send it to me, I can give it to him.
we can take a picture of it and send it to them right now.
I'd be happy to take a quick look
Give it to them.
or abstain if we have enough
No.
votes.
No, don't abstain, don't.
Don't say. It's too important. Yeah, if you look at the last one and you go down to candidates to the board of directors, the application is there, and that's the old one with the red thing totally missing.
There's
It's not even
definitely
red.
a communication though between the marketing director who puts the newsletter together and what's.
And if you go to MO9 and look at the attachment there, and then you go to the one on the board's website. So those are the three places I know they're.
so Augie, give me an email address here.
What's that?
Give me an email address. I'll send this to you.
Minutes on the
DHEVELUS
committee minutes posted
@gmail.
with the options removed.
Right.
And now also
Echo H.
there's one this week and those.
CH.
There's one in this week in Ocean Pond, which I think
Oh, I
is
got
gonna
it.
be the same as this with it
I got
removed.
it.
Hopefully it pops up.
Where you
Yep, I
got the
got it.
other one though, if you go to board of directors and you go all the way down to the bottom to the application, it's the same one with the red thing there that says these are optional.
Yeah, and that's what's on the red.
Right, that's it. So I think two of them are the same, I believe, and the one is, the board is different.
Removal of the
They're all wrong, right?
difference is the removal of the optional.
Right. That's what I've seen. I can't find I couldn't find the one he's talking about, but I do know. I looked at three different places. And the one with the newsletter and the one on MO9 are basically the same, because somebody took that statement off of MO9. I don't know how. Go to MO9.
I just sent it, Augie.
Okay. What are you looking at? Oh, it's not gonna go all the way to the beginning of it, the very beginning of the newsletter.
Well, I did see it, but it didn't have a clickable.
Well, it has a click to it. Keep going all the way up
I got it.
to the beginning. You're not there yet. You gotta take a slider and just slide it all the way up. My reading glasses don't work close up. Keep going. It's
Keep
above
going
that.
down?
It's above that. People look.
That's the front
Okay,
page.
now. This is the Spring Ocean Pines newsletter. It's not their weekly one you're looking at. Look at their weekly
Oh,
newsletter.
you want the
The
week?
weekly newsletter is the one that's on. No wonder you couldn't find it there.
Okay, because I was under quarterly.
Go to the regular newsletter. I think you can find it under news.
Yeah, if it's on the local, latest news, you probably scroll down to find it.
Yeah.
What's the hearing?
Augie's got his. Okay. Well, this is handsomely done.
Yeah, except it's not in color, so really, we have the seal at the top left corner would be in color.
Oh, that's right. Yep.
So we had a set. I think Augie got color. Augie got color.
Okay, thank you.
Okay.
But anyway, that's not really important. I'll send you the link to it because I don't think I erased my last
Trouble with
the
the,
newsletter.
this website in the sense that I don't think it's as user friendly.
So this theoretically is in compliance with the bylaws.
I
In a rough sense.
I believe so,
Yeah.
yes. The language may not be perfect, but I think it, just so you,
The 10 years is correct.
No, 5
no,
years.
it's 5 years.
This one, you gave, oh,
Yeah, 5 years.
The one that has the watermark draft.
okay, here we go. Okay, that's the one I got. You're mine.
So, the difference, if you pulled up, did you pull up the one of
Which
the,
one?
one of the other forms? Like from,
Here's the other form.
no, I
Go to
got,
board of directors
go to the board of directors.
Go to Board of Directors.
and go all the way to the bottom.
Scroll all the way down to the bottom. As far as you can go.
Right.
There it is. Click on that. Now go scroll down a little bit.
Section 2.
Keep going.
There you
There
go.
it is. See the red?
Hold it right there.
That's it.
Now, if you, I can walk you through this. This version, as opposed to the elections committee version, includes the sentence right in number 2, where it says these questions are optional. So the elections committee struck that. Okay. If you look at the specific questions, 1 through 4 are consistent with the bylaws, with the one exception that question 4 says, have you been convicted of a felony within the past 10 years? The bylaws basically say 5 years.
Right.
Now, there's some other language about have you completed the sentence because they take into account parole or probation requirements, et cetera, but basically it's 5 years.
Right.
Question
7.
right. 5, 7, 8 are all in theory optional questions. In other words, there's nothing in the bylaws that requires them. And then there's another eligibility question in the bylaws, which deals with whether or not you are a plaintiff or a defendant in an active lawsuit filed in Maryland or federal court in which Ocean Pines is on the other side, including appeal. The suggestion would be to delete actually, I think 6 as well. From 5, 6, 7, and 8. 9 would stay, but it's just reworded a little differently because the issue of whether you are a owner, the owner is a corporation, LLC, partnership, or agency. So,
And then the addition of the other bylaws question about plaintiff or defendant in the
Right.
active lawsuit.
right. So there would be six
So that's
questions.
what you see on the new form.
Right.
Six
I see
that
that
would
there.
have to be answered. The other change, by the way, just so we're clear, is on page 2, almost all the way to the bottom. You'll see on the elections committee version or on the board's committee version, there are 2 separate, one's required attachments, the other is optional attachments. I deleted the optional attachments out because if you look at section 3 up at the top,
Right there.
you have the option of attaching that information anyway.
Yeah.
Right.
So it's redundant.
It was unnecessary.
Right.
Yeah.
Now, the only other thing I will tell you, and I said this before, is in section 4, down in the verbiage below 1 through 5, there's a couple of dates in there, I think it's May 10th or something like that. I did not check on those dates. So dates may be right, they may be wrong. I don't know. I didn't check them.
Well, so, what I did was, because there weren't really any changes to 4 other than removal of that option, I read through the old form. And the old form, or the version that came from council, I guess it was, he modified some of this language, and I read through it, and it was, I don't know, it's kind of legalese. So those changes that council had recommended, and I would call it version 2 of the form, are actually incorporated here in this language.
Okay.
I don't necessarily think it's all that noticeable, but if you do lay this section 4 up against one of the old section 4s, you can find some of the differences. Some of it was just wordology. Some of it, I think you actually deleted sentences.
Right.
I don't remember specifically, but I remember thinking as I was doing them that they weren't controversial. It wasn't something I thought was controversial.
Yeah. Well, it's certainly better than what's out on the internet right now, and it's in compliance
It
with the,
complies.
right.
Yeah.
And that's why I think the charging document should recommend as an interim application for this year that they approve this.
I'm fine with that.
You're fine with that? You have a charging document to take it, and this is in.
We didn't vote.
You okay?
I think that makes sense.
Jim, you got any comments?
Well, this one is dated and marked as a draft, if you'll notice.
Yeah,
See, got a date down at the bottom. It's got a draft watermark across the middle of it.
yeah. I mean, it was very
I
professional.
You're learning how to do it. All work goes to Steve from now on.
Yeah, the draft across it, we should really, and even the red lines, the draft across it, because it's easier in a Word document to add, take that
What
on
am
and
I
off.
charged with? What is my?
I need a charging
A new charging document.
You charging that
from the
references
committee
this?
to the board that basically is, the subject matter is M09. You may be able to pick up some of the language that's in the prior charging document, but I think the most important thing is to stress that there are conflicting applications on our website.
You want to do it?
Candidate application, none of which are in compliance with our board of our
Okay,
bylaws.
I will draft it up
okay.
and I will send it to you. I'll send it to everybody, right? But I'll send it to you. Because I have some of this language.
Okay.
So I will draft up a new charging document for that.
One recommendation,
Okay.
would you not just want to put the year in, because this is for this year only? They need to straighten it up by next year.
Uh,
I don't know.
Fine. I mean, I don't,
Does it
candidly,
make a
I don't
difference?
know that they'll revisit this. I mean, it might be a good idea that they do. There might be.
Yeah, leave it that way. At least you got a document that should be
Yeah,
consistent.
I mean, I think you could basically say the bracketed word year could be deleted and you can put in any year you wanted.
Right.
So, yeah,
Right.
that's fine.
Oh, I think that was actually the intent.
Yeah, I would think that's probably what it was.
But
Okay.
if you look at the old form, it had no year in it.
Right.
Okay, so we're done with that.
Okay,
That was good.
good.
Oh,
Now you're not gonna use the old charging document because the only problem we have right now is this. as
well, the
a
old
meeting-
charging document goes into more stuff.
Right,
It goes into language and.
yeah, because that'll confuse the issue if you send it. Or would you make that an attachment?
No, I
and
don't,
say,
I don't think so. I think that'll
Okay.
slow the whole thing down. I think that's why
I
we
think
have
so.
a new charging document that just says, hey, there's 3 of these out there, none of them are right.
Right,
Attached is a recommended
none of them,
draft that complies with current bylaws.
Yeah, and let me just point out, and I think Jim said this earlier. The attachment to N09 that is currently there is actually part of the resolution. So the resolution has to address M09. Now, I don't know how you may want to word it, but there are matters relating to M09 that need the board's attention. But the
Immediate.
first issue has to be the application because of the time frame we're looking at for the election. So I think something
Yeah.
along those lines
Yeah.
would suffice.
yeah, because the board can approve this application at the meeting
They get it done-
to correct an error,
If they
can't
get
they?
it done by the April
No.
meeting,
It's part of the resolution, so
It's
it's,
part of the resolution, so it should go to the resolution amendment process. Now, you don't have to wait till the next regular meeting.
Right,
The second reading could be immediate. Next,
right.
call special meeting for that following the regular meeting. That's not very good practice, but that can be done.
So rather than do a,
We should put
could it
that
be
in
done
there.
under the email process where we all agree?
it could if you could get everybody to agree, but I'm not sure you will. But,
Who?
try it.
The point is, regular meeting for the first reading,
So
second reading, whatever meeting.
I'm with you.
Yes.
I get
Yeah.
that. So that really what we need is not a charging document. We need a first reading. I need to do a first reading
at
on
the,
this.
at the,
And
Well, can we state that this charging document is to serve as the first reading?
no, it has to be separate. There's a separate form.
But you don't want a charging document for review. What you want is a first reading.
Yeah, you're right. You're right.
Of an attachment or an application change.
Right. Okay.
Which you have,
Well,
which you have.
I have the application.
what
I
you
have to-
can
I have to
do-
Right, the first reading form.
what you can do is with the charging document, you can attach the resolution M09 with the correct application attached. And that's what the first reading's all about, isn't it?
No, because we would still need, because we still need them to get through the first reading and then have a second reading with, which is the motion to approve, which we can do at any other meeting, not the regularly scheduled. meeting.
Including,
So, and we don't have the time. The problem is the time.
Well,
A charging document is not required.
No, I
The
think
charging
that's
document
correct.
is not required. You have the draft document for
Right.
review.
Right,
So all you've got to do is submit.
as a first reading.
That's right.
Yeah.
this is, I think this is
as a modification of
Mhm.
09.
Right.
And look, I will have to make it clear to the board that we have 3 conflicting applications, none of which are compliant with our bylaws. And in order to get this done, we have to get it. Now, what I can say is the committee has reviewed a draft of this application and found no problem with it or
Right.
endorsed it or something like
Yes.
that. I can say that. But,
We should vote.
Yeah, we'll vote on it.
but
in a minute.
the board has to understand, there has to be another meeting, whether they vote unanimously by email or
Right.
we have a special meeting just to address this application. We've still got to get it
do it
done.
right after.
So all you need
Do
then,
it the same day as the,
it's gotta be-
all you need then
it's gotta be in-
from us
right.
is
Yeah.
this application saying that the board or the board, the bylaws committee has reviewed this. It's to make it is now consistent with the bylaws and blah, blah, blah.
And I'm gonna call Tom and Piatti and talk to him too.
So then let's vote on this,
Okay.
make it official that we agree that that is
The correct.
presentable to the board.
Okay. Since
I make a motion that this be presented to the board for first reading.
Augie, you want a second?
Second,
Any further discussion? All in favor of approving and forwarding
This,
this current application?
Draft 324.
draft- Yeah, the draft from 324. Please say aye.
Aye.
I,
Any opposed? Thank you very much. There you go.
What needs to be made clear is the resolution X does need to be addressed at some time.
Yeah.
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 okay.
All right.
Whew.
These are such, exhausting meetings. All right, so I'm gonna close that one.
How close are we getting to 2:00?
To two? Oh, we're way past that, buddy.
We're at 3:25. Your wife should be calling.
I was gonna say, my,
Yeah, we joked about that at the volunteer dinner. It's like,
Oh.
I told his wife, I'm like, oh yeah.
She walked in my
I'm running
phone.
late because I see his phone light up, My husband at least knows that we never end on time, so,
Yeah.
All right, so anything else priority wise that we need to do for you? Do
you're
you need to
okay.
update some governance things?
What, do you want to go through this real quick?
Yes, let's
Yeah,
go
if
through
you-
it real quick.
Make sure
Okay.
you're good.
Man, this thing is becoming a 10-page document quickly.
So B02, I've got, we've got some red lines that are approved for first reading.
Okay,
B03, I just updated the notes to say that the first reading is scheduled for this next meeting coming up.
okay,
B05, that we approved some red lines. They're going to be submitted for the first reading this
Okay.
upcoming meeting. Same thing with B06. I updated the notes on 7 to say the second reading was completed, so I updated the date, the red went away. Same thing with 9, red went away. No, I'm sorry,
let's go back to
7.
7. What you're gonna do then is say it was approved and you're gonna change the dates.
Oh, I thought I did.
Oh, you do have them. Oh, yeah, you already have them.
Yeah.
Okay,
Yeah, I changed the date.
okay.
So 9, first board reading, get the wrong glasses today. First board reading complete, forward to council for review. Okay, so I just updated the notes on 9. C1, I updated the notes, charging document created to ask about annual resolution review inclusion. No, I didn't update. That's the old notes. So I didn't change anything on C1.
We never got that charging document
Yeah,
in front of
We
it.
haven't done anything with that yet.
Okay,
Well, we're still waiting on the
Right.
executive committee.
Right.
okay.
C10, we haven't done anything with that. That's on back order.
Mhm.
F1, that is still. That's still back.
That's on me.
Yeah, that's on-
F4.
Yep,
I have charging documents too.
Okay.
those were on, those were low pri before and you're moving those up.
Right,
Right,
I'll
the
do
priority.
those in April.
Yeah, you'll notice I added F5 here for the convenience fee resolution, but I only did that
Just to give it a,
because on here it said we're kicking it back to us. But I'm gonna take that back off now.
okay.
I'm gonna remove that.
Well, leave F5 as an entry and I'll send you a quick, when I look at the.
Oh,
Yeah.
okay, all right.
Yeah,
See where it was referred to.
Okay. M1, I'm gonna update the notes to say that it was referred back to ARC for further consideration.
okay,
M2, I didn't change anything. M5, I updated the comments. That the second reading was complete and I updated the date, so the red went away.
Right.
and then
M,
you're gonna take the history out then beyond that on the next one, so we don't have all that.
I don't know, do you think I should, do you think once the second reading is done, I should delete the previous history?
Yeah, the only reason I would is to try to keep the form to a minimum. If they're active, then you want the complete
Yeah.
history.
But
But once it's resolved, I would either, if the resolutions change, then the resolution date changes. If not, then just the
Yeah.
review date
So any-
changes.
except for things like M9, where we know there's an old issue,
Yeah,
Okay, so okay, I'll do that. So anything that has been approved for a second reading and the date and the
Yeah,
review date updated, I'll remove the previous.
yeah, because that way to form the history, who cares what?
Well, I've also got, I'm saving these old copies.
Yeah, I
Worst case scenario, we could always go back and look.
I
at
have
those.
all the old
Okay.
ones too, yeah.
Okay, I'll do that. M6, I don't think I changed anything on that.
I think the elections committee indicated they were preparing something, but
M7, I didn't change anything on that.
Okay,
And then M9, I'm gonna update with the comments that we're creating a charging document specifically to address the
Canada.
candidate form.
mhm.
Okay. Those are my changes to the project.
All right.
Shazam.
So I'm gonna say that we have accomplished enough for today. Unless anybody has.
We're only a
anything
half an
that
hour
needs
over.
done.
Yeah.
So just to confirm, our next meeting date is not until May 12th.
Oh.
Okay?
All right, this was
We
our,
don't have an April date.
this was our
Today
April
was
meeting.
supposed to be for our April monthly meeting.